Hello, everyone, and welcome to this LexisNexis webinar on M&A Contract Drafting, best practices for corporate and law firms. We are so excited to have so many of you with us this afternoon for this cross-border panel discussion featuring speakers in regional roles based in Hong Kong, Singapore, and Malaysia. A couple of quick housekeeping notes before we start. Please note that this webinar is being recorded and the recording will be made available on our corporate websites. Secondly, there will be time allocated at the end of the panel for audience questions, so please feel free to submit any questions you may have through the Q&A box, which you should see at the bottom of your screen, and the panelists will endeavor to answer as many as possible at the end of the panel. Before we dive into what I'm sure will be a vibrant panel discussion, I'd like to invite my colleague Jerica to introduce you all to a brand new legal drafting solution available now in Hong Kong, Singapore, and Malaysia, Lexis Clause Intelligence. Over to you, Jerica.
Thanks, Rosh. Hi, good morning, everyone, or good afternoon, everyone. My name is Jerica, and I'm a customer success consultant based in LexisNexis, Southeast Asia. So now I'll be giving you a short demonstration on what Clause Intelligence is about. And just to give you a bit more understanding of how Clause Intelligence works, it is actually powered by artificial intelligence. And what this tool does is to help you by surfacing out recommended clauses based on your uploaded template agreements. Clause Intelligence is also available in other jurisdictions, such as Malaysia, Hong Kong, and also Australia, aside from Singapore. So let me take your attention to the screen, the shared screen. This is the homepage of Clause Intelligence. And on the left-hand side, you can see some simple instructions for you to get you started. At the right side of the screen, you also can see a drag and drop your file. So there are two methods for you to upload your selected template. You can either drag and drop, or you can simply just click on the upload button. So once you have chosen your template, you can begin by clicking on the upload button. And just to assure you that how we've developed Clause Intelligence at the back end is that it will not store any of your data on our LexisNexis server. So once you exit this page, it will not save any of your existing documents that you have uploaded. So once you've chosen the documents that you like to upload, you can simply just click on the upload button. My screen over here, you can see that it's split into two panes. So the left side of the screen, it actually gives you a full view of your uploaded template agreement. And on the right-hand side, we have the relevant clauses which have surfaced out based on your uploaded template. The extreme left-hand side of the template, you can see there's a vertical search bar over here. So this allows you to toggle seamlessly from one clause to the next clause. Let's take our attention to the right-hand side of the screen over here. You can see some recommended clauses being made. So our clauses actually surface out from different commercial positions. Firstly, if we look at recommended clause 1, you can see that it is made from the perspective of a pro licensor. And if you scroll down a little bit more, you also can see that we have a pro licensee perspective over here. So Clause Intelligence surface out clauses from different commercial positions. And secondly, the clause recommendations are also made from various jurisdictions. So on screen over here, you can see that it is made with both Singapore as well as the UK recommendations. This, of course, depends on the subscription level that you have. If we'll take our attention to the top left-hand side of the screen, we have a manual selection feature for you to toggle. So the purpose of having a manual selection feature is for you to zoom in and look at the subclause levels. So for example, if we'd like to look for recommendations being made for the subclause level of 4.1.1, you can simply just highlight the whole entire subclause. And you can see that there are 4 recommended clauses being made for that specific subclause. And another thing to note is when you're in manual selection mode, the clauses that surface out will also be highlighted in orange. To simply toggle this off, you can switch off the manual selection feature at the top left again. And last but not least, if you're reading through the recommendations and if you find that there's something that's not being recommended somehow, you also can further extend your search by clicking on the magnifying glass at the top right-hand side of the screen. Yeah. So that will be all for the Clause Intelligence short demonstration. Just to reiterate that Clause Intelligence was designed holistically to help you in your legal drafting. If you'd like to experience this for yourself, you may do so by scanning the QR code, which will be shown on screen.
Thanks very much for that, Jerica. As Jerica and I mentioned earlier, Lexis Clause Intelligence is currently available in Hong Kong, Singapore, and Malaysia. So please feel free to reach out to us or scan the QR code on your screen for further information. Now, I would like to introduce the moderator of today's panel discussion, Rachel Wong. Rachel is the creator of Founders Doc, an online resource that aims to smoothen the launch process of early-stage companies in Southeast Asia. Rachel is joined by a panel of M&A experts, and they are Tiai, Chief Counsel, Business Development at Marubeni Corporation, Jason, Director and Head of Asset Management, M&A and Flex C-Suite Solutions at APAC Frontier Solutions Limited, Raphael, Head of Corporate, Commercial and M&A at Law Partnership, and Simon Look, Partner, Hong Kong, Shanghai, and Chair of Asian Practice at Winston & Strawn LLP. Again, please do feel free to participate in the conversation by asking any questions you may have through the Q&A box, and the panelists will endeavor to answer as many as possible at the end of the panel. Now, without further ado, over to you, Rachel.
Thank you, Roshni and the LexisNexis team. Thank you, everyone, for being part of this webinar and spending your afternoon, or for some of us, the mornings with us. I'm Rachel, an M&A turned startup lawyer, and today I'll be the moderator for today's session. Please do send in your questions at any time, and if you see my eyes moving, that's because I'm reading your questions. And in this conversation, we are going around Asia Pacific to cover a wide range of topics from different regions. We'll be talking about SPAC deals, as well as US-China tensions, one of the things I like to talk about. We'll be talking about deal making in Southeast Asia, as well as emerging markets and what we should be looking out for in M&A deals. We'll be talking about family offices, which is a rising phenomena in the region, as well as Japanese deal making and the renewable sector trends. We'll start our conversation with Simon. Simon is currently having his camera turned off. So we might have to trouble you to turn on your camera so that we can...
Can you turn it on for me? I could not, the host stopped the...
No problem. It's okay. No worries at all. We can skip our conversation for a little while and move to Malaysia for a bit, which is, I'm based in Singapore, so Raphael is based in Malaysia, just a country, neighboring country. And perhaps we can start our conversation with deal making in Southeast Asia. So Raphael, thank you for joining the conversation today. The first question I have for you is, what are some of the unique characteristics of deal making in Southeast Asia as opposed to deal making in other countries? Are there any trends that you see, anything that the lawyers as well as practitioners in this conversation should be aware of?
Thank you very much, Rachel. I think from the very offset, I think I would like to take it from the geopolitical aspect of this, because I think because of the current geopolitical tensions between China and America, we see in Malaysia and also the region a lot of investments coming from where companies are trying to diversify production base out of China. So we have a lot of M&A transactions involved in Malaysia, particularly from a geopolitical aspects when they are trying to relocate their production base. So I think that's a very important phenomenon. And some of the top investors we are looking at, we are seeing is from the United States and of course Singapore and interestingly Japan. So these are the top 3 M&A acquisitions of countries that are coming to acquire or relocate production bases in Malaysia. I think the other thing that we are also continuing to see is this strategy of looking for deals as a strategy for expansion from 2 aspects. There is a trend to diversify or to sell assets that are non-core, and at the same time you're seeing a lot of companies picking up assets at a fairly cheaper price in terms of trying to expand within the region. So I think those are some of the very common trends that we are seeing in Southeast Asia, particularly in Malaysia.
That's great advice. What about politics? I mean, with the recent news and what's happening in Singapore, we have the presidential election taking place soon, lots of interesting candidates, as well as the different elections happening in the region. Do you have any tips for M&A lawyers in terms of perhaps drafting transaction documents, or perhaps the timing of the deals? Are there any tips that you can give them?
Well, I certainly think that in terms of warranties and indemnities, it has become tremendously critical, and it's something that obviously M&A lawyers have always been looking into. But I think more so with the current political trends, not just in Singapore and Malaysia, there is a political transition in Malaysia, as you all may know. That state election just occurred, so there is a transition period, and there seems to be a little bit of uncertainty as to some of these policies and investment rules. So I think in order to protect any M&A transaction, I think the clauses on warranties and indemnities take on a special place, because I think we need to be very, very careful of that. The other thing would be conditions precedent, of course. Now, with conditions precedent, is one way of managing the transaction from a political aspect, whereby policies may change quite dramatically in a very, very short period of time. New rules may be implemented. So I think in terms of warranties, indemnities, as well as the condition precedence clauses, take on a much, much more important role.
I fully agree with you, Rafael. I think when you're doing deals in this region, conditions, precedents, reps, and warranties come into play very important, as well as timing, as well as hiring the right local counsel.
Yes,
So
yes.
yeah, perhaps doing deals in countries which, have restrictions on the local ownership, as well as, certain requirements such as, how many directors must be locally appointed, or whether you need a board of commissioner. All these things are very important when we're doing deals in Southeast Asia, as well as trying to sense the climate in the region. As different parties get elected, they might expand or become more conservative on foreign investments.
Yeah, Rachel, if I may, I just want to bring out a very good example as to, because of political transitions that's happening in Malaysia. If you recall, Malaysia is the exception in the region whereby we do not have merger controls under competition law. So in 2021, in December of 2021, the Malaysian cabinet decided that as a policy, they will bring in merger controls. And the roadmap for the implementation and the bringing about of this new legislation was to be done by October of 2022. Now, because of political transitions and because of elections and so forth, and because it is not a absolute majority government, such things have been put on the back burner. And so, and of course, recently, unfortunately, the minister of who is in charge of competition law in Malaysia just passed away. So now we have another transition, not just political transition, but a transition of a new minister being appointed. And obviously, when new ministers come into their portfolios, they'll take some time before things move on again. So that's one good example of we may all plan and have plans, and there's anticipation of what's going to happen, but it may not happen because of many of these reasons.
That's a very, very good point. And of course, when you're drafting your documents, do consider Lexis Clause Intelligence drafting tool as you navigate your documents. Thank you very much, Rafael. And just in case you do not know, Rafael is also the author of Pricing Strategies for Legal Practices. So if you have any, you want any insights from that, that's the book to go for. Perhaps I might do a little bit of detour and go back to Simon from Hong Kong. And I'm very excited to have him here because Simon has great insights on two things that I'm very interested in. The first thing is spec. As we hear this term a lot in the newspaper, we hear that, Grab wants to do a spec, or a lot of the startups want to do a spec. What exactly is spec, and what are the spec trends that you foresee in the current market, Simon? If you may unmute yourself, then we can hear you better.
Thank you. I'm glad I'm back on.
Yes.
This is a topic that I have covered in my books published by Lexis on cross-border mergers and acquisition, and also private equity. We have published 8 versions now, 4 versions each. SPAC is like a trend. It goes up and it comes down. I have done the first SPAC in Hong Kong about 25 years ago. At that time, it was called Development Company, Blank Check Company. And then since then, last couple of years, we have formed SPACs out of China, Singapore, Malaysia, India, and other places, and of course in the United States. And we have done about 4 to 5 de-SPACs, which is the time when you inject the real business into a SPACs. So what are SPACs? SPACs are very popular because in 2021, I give you some figures. 613 SPACs were formed in the United States, raising $145 billion, increase of over 90% the previous year. And then the next year, 2022, only 86 SPACs were formed, raising $13 billion. And then 2023, only 16 SPACs were formed. But as I said, this is a trend. It goes up, it will come down, it has come down, and I'm sure it will go back up again. So what is a SPAC? A SPAC is a company formed by experienced sponsors. They raise money from the public and put it in interest-bearing trust account. And the money is not touched, not used, until they found a target. And after that, there is a shareholder approval, and shareholders can decide to vote and stay with the company or redeem their shares, in which case, then the cash will be reduced. So as far as I'm concerned, people get listed for 2 reasons. They want a listing vehicle and they want to raise money. SPACs reverse the order. They got a listing vehicle first and raise money, but they allow the money to leave. So I'll use an analogy. If it is very difficult to book a concert hall, a sponsor will go out and book in advance 6 years from now, 4 years from now, the concert hall, and sell the tickets without telling you who the entertainer will be. But you have an option. You can sell the tickets back to the sponsor and someone else may buy it. So this is what a SPAC is. They raise the money, they got it listed, but you don't know what the business is about. And you have a chance to review and vote on the target, which is the acquisition. So SPACs are very, very attractive because theoretically, it cuts down on the amount of time you need to get an initial public offering. It also gives higher premium to the target, and it also can have earnouts and also various other advantages like using profit forecast during roadshows. All of this has done, and unfortunately, it attracted the wrong type of investors now. Mostly, the investors are what they call hedge funds. They are very short-term investors with a lot of money. So every SPAC will be successful. You can go and raise money quickly, but most of them will leave despite what the target company will look like. Because for them, they are interested only in the warrants that come together with the investment. So I think it is still a viable option because for a company, let's say out of Singapore, Malaysia, Thailand, they had a very good subsidiary or a very good investee company. They can raise a SPAC first for their own investment, which is permitted nowadays. You can say in the registration statement that you're raising the SPAC and one of the permitted investees will be your own company. So with that, you can have a listed vehicle ready at any time to raise money. And that's a very big plus because IPO, everyone knows, you work like 15 months and then you don't know whether or not it will be successful. But a SPAC, you are assured that there will be a listed vehicle if you do it properly. But a field note, as I said, the trend, there have been changes. People are now looking at smaller SPACs. You don't need $1 billion SPAC. You don't need $500 million SPAC, because if the money is leaving, why do you need to pay 5%, 5.5% for some money that would not stay? So the trend now is about 75 million. And then you look for quality targets that would, on their own, even if they're on an initial public offering, would do well. They have growth potentials, they have proven track record. All of this will be very helpful. So please remember, SPAC is only an instrument. It is only as good as the singer singing in the concert. It doesn't matter whether you get listed by SPAC, you get listed by IPO, by reverse merger, by listed shell. At the end, it is the target company that is performing, that people are following and voting with their money. So I still believe SPACs, despite the downtrend in these 2 years, eventually we have seen about 3 or 4 cycles where SPACs would come back. And I think in the future, they will come back to be a useful instrument for companies that are assured of the target being maybe their own subsidiaries. And then they can inject it into the SPAC for a very successful fundraising afterwards. So that's a very brief introduction of SPACs, and I've done many lectures and seminars on SPACs themselves. But I still believe, like IPO, like private placement, like private equity, SPACs will be around.
Thank you, Simon. Someone asked a question, how do you spell SPACs? It's not spectacles, it is SPAC, Special Purpose.
SPAC, Special Purpose Acquisition Companies.
Yes.
It's just an acronym.
Yes, that's right. So remember, if you want to do a SPAC, get a good singer like Blackpink, and you have a higher chance of being successful. Thank you, Simon, so much for your answer, and keep the questions coming in. We'll be sure to answer them once I receive it. The second question I have for you, which is the question I'm excited about, is in the context of rising US-China tensions, how does this affect M&A deal making? And have you noticed certain trends in the market or new structures in M&A deal making? How should practitioners navigate this current market?
Thank you. Law firms will tell you they've seen a lot of impact because of the tension between the United States and China. Definitely, pessimism is the theme. We know that COVID has caused a lot of economic disruption. If we add on to it the tension, as our friends here have said, we are changing. Foreign companies in China are now looking for alternatives. They're going to other East Asian countries, Singapore, Malaysia, maybe even Taiwan, and maybe Thailand. These are the beneficiaries of what the tension between United States and China has brought about. And I think it is also important that the economic environment being what it is now, there has to be some creative and maybe borrower-friendly financing available. We have seen covenant-like borrowing where there are much less restrictions on borrowers and maybe less protection for lenders. But all of this would help to make the transition and from China into other Asian countries. But as I said, as in the case of SPACs, it is a cycle. I think the two countries will work it out. There will be times when we'll see an improved relationship, and then foreign company will go back. But at the moment, the regulators have done, privacy, restriction on transfer of personal data. All of this are not very helpful when you make investments, because there are too many local regulations that will be to be aware of. Unfortunately, every country is trying to better each other by raising anti-trust, by raising a lot of corruption, law, privacy, and also, I guess nowadays it's national security. All of this will make it more difficult and more, but for a company which has a strategic view, a long-term view, they may be able to find opportunities during this difficult US-China trade tension period. So like others, I think we have to wait.
That's right. Thank you, Simon. I think Rafael and I are on the same page when we see the trends coming in. On my end, I see some Hong Kong companies flipping into Singapore as a request from US investors to avoid any potential pitfalls. And the two countries have diametrically different systems. I mean, just browsing the news today, I saw an article about BRICS intending to become stronger. And the way they regulate IP, for example, is also of a different framework altogether. So it's be quite interesting to see what the next 10, 20 years will look like. But I do think it's important for M&A lawyers to prepare themselves for different systems, as well as how to navigate, a market that is a little bit fluid.
Rachel.
Yeah.
Sorry, Rachel. If I may, just to add on to what Simon said and what you just said about trends in Southeast Asia, Singapore, Malaysia, Thailand being the beneficiaries of this geopolitical conflict. One of the things that I've realized in the last couple of months is that increasingly a lot of these investors, particularly from the US and Europe, are asking for ESG type clauses. For example, they may ask, I mean, even the simple things like leases and tenancies. Is it a green building? Is it a net zero building? And they want clauses, if it is not currently a net zero building, clauses or a commitment by landlords to convert the building in the next 5 years, or so we are increasingly seeing a lot of such pressures, and I guess that's a trend that we will need to watch very carefully.
That's correct, Rafael. Since you're online, there's a question that's actually for you from the audience. And this is the question, what is the extent of law firms' involvement in specs moving forward in Malaysia? It seems like a very Malaysian-specific question.
Well, I've done a couple of specs, but it doesn't seem to be very popular currently. I think the last 12 months, 24 months, we haven't, well, I mean, the numbers have dropped quite a bit. But very often when we are talking about specs, Simon will probably clarify this, they are often thinking of ultimately listing somewhere else, where they'll be listed as a way to exit Hong Kong, NASDAQ, wherever it is. So very often it has got a lot of cross-border elements there. I certainly haven't seen, it's not very popular to have domestic specs.
I like to make one comment. Singapore and Hong Kong also have specs as a possible listing alternative, but unlike the US, it's not attractive because it's more burdensome and takes longer than a regular IPO. So it doesn't make sense. The United States, despite all its issues, they have a disclosure-based system where a spec theoretically can be faster and attract more money. But Singapore and Hong Kong, I don't think they are trying to beat the United States in terms of number of specs and number of, so in Hong Kong so far, I don't think there has been any de-spec. So it is difficult, and it may not be the trend in these two countries to have a very popular spec regime.
Yeah, neither in Malaysia, Simon.
Yeah, so if anyone from SGX is listening, that's a cue for us to become more competitive. And then we move the conversation a little bit to family offices. And we have Jason, who is the head of asset management of APAC Frontier Solutions. Now, if anyone is Googling his name right now, you may not be able to find him because his company's website is down, but his company does exist.
We are having technical issues, but we hope to have that sorted out soon. If anybody would like any more information about the company or myself, please feel free to ping me on LinkedIn, but we'll get that sorted shortly.
Thank you. So the question I have for Jason is about family offices and ultra high net worth individuals. Even in Singapore, especially in Singapore, we see much more family offices being established and ultra high net worth individuals doing investments in what would be seen as usually investments that corporates engage in. So what are your observations on investment trends, and how can M&A practitioners leverage on these trends?
Well, I think one of the things that we've seen a lot of, generally when somebody envisions a family office, they're thinking about, especially a single family office, you're thinking about a very broad range of services that family office is providing, especially when it comes to the management of the family's wealth. One of the things that I saw both in my previous work experience and just with trends with family offices nowadays is there's very much an interest of family offices to get involved in private equity style investments. It's gone from purely a wealth preservation setup to more of a, we're going to set aside a certain percentage of our family's resources, and we're going to put those into what are basically lottery tickets. And that means that those family offices are they're both going to be on buy side and sell side, because you're going to end up with offices that have invested in growth stage enterprises or even complete startups and are looking to exit from those or at least supplement the investment that they've already made into those companies, or they're actually going to be out searching for targeted investments. So I think that's an interesting trend. So you're going from trading in traditional, as we would think of, wealth preservation assets and securities, to being a little bit more open to risk, although there is certainly going to be a limit to that as well.
Thanks, Jason. And do you have a understanding of why this is the trend, or it's just a trend that's happening with no reason behind it?
I mean, honestly, it's really nice to think about the possibility of being on the ground floor of a unicorn. If you've got that opportunity out there, there is enough just between just the way the world has shrunk information-wise. It's a lot easier for a family office to go out there and find. There's so many events and networking events and organizations that are designed to introduce interesting startups, growth stage enterprises to the world, that there's access to those potential investments. And I think that's made a big difference. So it's not just a matter of within your own network trying to figure out who's taking a risk and starting up something new. It's you can actually get involved in global business networks, events, just available information and platforms that will introduce you to these companies. So I think that's made a big difference as well.
That's a good observation. How about navigating requirements that's typically required from Western style documents? So in Western style documents, we typically see very heavy or worded clauses on anti-bribery provisions, anti-money laundering provisions. And sometimes it's just not in the capacity of a portfolio company or the investee company to give them. To put it crudely, some of it is customary in certain countries. So how do you navigate these situations, or is there no answers to that?
Well, I mean, I think one of the issues you have to, we're talking about drafting the documents here for a potential transaction. And as you can tell, my perspective is more from a PE and a private placement perspective. When you're even prior to beginning to draft those documents, you need to take these type of issues into account. You need to have identified, by the time you get to the table and you're drafting the documents, there's probably going to have been a long conversation between the parties that are involved in the potential transaction. And part of that conversation needs to probably be a realistic point of view on what the regulatory issues are going to be surrounding that particular acquisition, that particular entity. That's especially applicable to Western money. Western money, especially, and when we say Western, at this point, we're really talking about the US, because that's and if you couldn't tell from my accent, that's where I'm from. So that's the stuff I run into quite a bit. But one of the major issues, and I think this was brought up by some of my other esteemed panelists, was the fact that US regulations do tend to be extra jurisdictional in terms of enforcement, and particularly things like antitrust and FCPA, and we're even talking about ESG stuff here as well. These are issues that are going to arise, and if it's the money side, the money is coming from a Western party, you have to be prepared to make compromises on that. The money side is going to govern that a little bit more so than if you are the sell side. If it's the sell side and you're investing into a company that is in the US or in North America, or even the EU at this point, which is becoming very strict on a lot of these matters, well, at that point, the asset that you're investing in is going to be governed by those laws and regulations anyway. So, the answer to that question is there's not a way around it. They're just, you need to be prepared in advance if that's going to be an issue, and then deal with it accordingly. If the pros outweigh the cons, or it's very simple cost-benefit analysis to having to deal with that. If the pros outweigh the cons, then move forward with it. If it looks like it's going to be too burdensome, and this could be true of a smaller acquisition, if you're doing a smaller private placement from a growth stage enterprise that really doesn't have the resources to comply with a lot of those rules, then maybe that's not where you should be looking for your investment. Maybe you need to be looking for that elsewhere. But I do think that always needs to be something that's taken into consideration. And I think that's part of the drafting process, is that you are doing your full due diligence on not just the parties that are involved, and not just the entity and the business that's being traded in, but also the regulatory and other issues that are going to surround the actual transaction and the governance of that business going forward.
Yeah, that's a really good point. I think just drawing Rafael's observations as well as Jason's conversation, we see a trend of US investors investing in Southeast Asia because of the growth opportunities over here. But sometimes it's just about explaining it to the US investors as well. For example, one of the provisions that I saw at the beginning of my career was more like, all subsidiaries must be wholly owned by, the Singapore company. But when you start a subsidiary company in places like Indonesia, there is probably—
Or Thailand, yeah.
Correct. It's very difficult for a subsidiary to be wholly owned. So, to go around that and say that, okay, it can be wholly owned or owned through nominee shareholding. So I think part of it is explaining to the stakeholders on how things are being run on the ground. Or in certain instances, in the US, for example, implementation of strong anti-bribery and corruption policies throughout the organization. But if you look at the companies within Southeast Asia, a lot of them are not yet in the developed stage. We're growing, but not to the extent that, where we have processes set up like very, very long-standing US companies. So it kind of takes time to say that, okay, if you want the opportunity to invest in this region as well, you might have to taper down some of your concerns to look at the key issues and to really zoom into the things that will be deal breakers. Thank you so much, Jason. And that was really, really helpful. And then we turn the conversation to Japan and Japanese deal making, which is very interesting. So today we have Tai with us, who is the Chief Counsel at Marubeni Corporation. Japanese deal making is very interesting. It goes at a certain pace, which is slightly different from the rest of the world. There are also a lot of processes to go through. So for practitioners over here who are thinking of doing deals with Japanese clients or Japanese counterparts, Tai, do you have any tips for them?
Thanks for that question, Rachel. It's a very interesting one and one that I get a lot. I think a lot of people know that Japanese corporate culture requires a high degree of consensus when making decisions. It's almost, we almost require unanimity. So deal teams are asked to incorporate opinions, comments from every key department of the corporation. It's like a 360-degree internal approval process, which is why, as you say, sometimes there is a complaint that we take a long time to make decisions on a deal. I would say the good thing about that is that once the company has decided on something, you can be sure that the entire organization is on board and committed, because everyone's opinion and comment would have been incorporated in taking that decision. And I think I will also address a point about how, there is a perception that Japanese MNCs are seen to be very cautious investors. So sometimes, people perceive our pricing proposal to be more conservative than other more aggressive players in the market. But from our perspective, it's that, we tend to look at M&A from a more holistic perspective. We see the deal as a start to a broader collaboration, which extends beyond the target asset. And so we see that, price is not the only value that we bring to the table. People do business with us because, they see it as the start of an opportunity to do more business together and to build a longer term relationship. So I don't know whether that answers your questions and whether that might be helpful.
Definitely. Let's talk a little bit about auction M&A. So in an auction M&A where the seller provides transaction documents and excessive proposed amendments, would it make the bid unattractive, and how should companies strike a balance between such a competitive bid and having the necessary safeguards and documents? I guess the reason why I'm asking you is because you're very experienced in auction M&As, which isn't so much a trend in Singapore, I think, but perhaps is much more prevalent in Japan.
It's prevalent in the sector that I work in, which is power sector, and we can touch on that a little bit more later on the topic on renewables. I would say two tips help. When you're trying to submit a bid in an auction M&A, the two tips that have helped me recently, first is to have radically honest internal conversations. And I don't mean honest, I mean radically honest, as early as possible and as honest as possible, so that we can quickly identify what are the real objectives in trying to bid for this asset. What is it that we're trying to get from this asset, and how urgent and real is that need? And then that helps us, understand in the documents what are the absolute must-haves that we cannot give in, we cannot compromise on, and what are the good to haves, which you may choose to mark up just from, just for the sake of preparing the proposal, but eventually in the course of negotiations, you might be able to give up on some of these points. So that, I think, is the first tip, like radically honest internal conversations. The second point that has helped my team is to have a good understanding of the competitive landscape. There's no such thing as confidentiality in the world, frankly, even though we are lawyers. It is always possible to find out who the other bidders are. Maybe we're not the people who go and find that out because, we're ultimately in-house compliance officers, but your business teams will know who the other bidders are. And if we know that, that's very helpful in preparing the proposal, because, for instance, if we know that the other bidders are established, prudent players, especially if they're Japanese players, and these would not be cowboys. So they would, in any case, be making the kind of markups that we are making, we would expect similar sophisticated markups to the transaction documents. So in that, in that scenario, you can take some comfort that, your markups might not make your proposal look so unattractive. But if you know that the other players are indeed cowboys, or, players that come from, more aggressive cultures, then not only do you have to consider how much legal markup you want to make, but commercially what your proposal is going to look like, because maybe there's just no chance that you win in this auction at all, given your company's risk adverse profile.
That's a good point. When someone changed my smart quotes into straight quotes or otherwise, I get a bit annoyed. What about renewable sectors? This is an exciting, sexy trend that's going on. I think, people care about saving the world. I mean, Rafael mentioned about ESG provisions. So there's been a lot of M&A in the renewable sectors. What are your observations on the latest trends, type of players, deal structure, anything that practitioners in this conversation can, leverage on and try to make a big buck out of?
I think there has been a lot of change, I think, in the power sector. So M&A deals in the power sector used to be project specific. This is pre-renewables days. It's usually the sale of a single large size coal or gas power plant in Indonesia or the Philippines, for instance. But renewables, especially solar power projects in Asia, tend to be maybe 1/5 the size of a coal power plant. And so what we see often is the sale of a portfolio consisting of multiple small projects and sometimes located in different countries. So this makes due diligence and transaction costs more costly and also more time consuming. And unfortunately, no matter whether you're doing a big deal or a small deal, the documents are the same. So that's that part that I think in-house lawyers have to try to manage. So that I think is one trend that we're seeing in the renewables M&A space. And I think the second thing we're seeing is, as we've mentioned just now, so far, most of the M&A deals in the renewable sector are auctions. Bilateral discussions are becoming a rarity because this asset class is seen as highly desirable. And so people do not want to have exclusive talks with you anymore, which used to be how business was done in a lot of, Asian countries when it comes to power assets. And because auctions are the norm, so then prices go up because people are trying to bid. So I think that is a very current ongoing market condition. And I would say the last trend that we're also seeing is new types of players are coming into the sector. So traditionally, when M&A deals in power sector used to be large size, coal or gas power plants, the buyer and seller are power producers who have decades of experience and track record in powering their entire country, for example. But with renewables coming into the grid, now we have young startup type renewables developers. Sunseap used to be a startup. I mean, although now it's like the pride of Singapore, but it used to be a startup. And then we have very wealthy PE funds on the other hand. So this then makes the market extremely competitive and everyone is trying to outbid each other. It's a transitional period, I think, for the sector. It's a very exciting time. And I think everyone is trying to find, their position in the market and their advantage in the market.
That's correct. I think I see a lot of startups trying to get involved in carbon credits. It's the next crypto trend to me. But for practitioners in this conversation, being in-house counsel in a renewable sector, portfolio company or company would be an interesting role for you to have. You will know that you're in the negotiating power seat. We have a question coming in, also relating to Malaysia, which is very exciting. The question reads as follows. The US ambassador to Malaysia recently announced that companies from US will invest about $100 billion into Malaysia. I'm going to move to Malaysia in the next couple of years. How do law firms and lawyers position themselves to facilitate the flow of these of FDI into Malaysia? I think the first tip is buying Malaysian property. I'm just kidding. Rafael, maybe you can help to answer this question. How can we better position ourselves for this trend?
Well, this question kind of caught me off guard, but I'll just think of what I've been doing for my American clients. Well, I think one of the things that we all have to understand that American investors come with a lot of wish lists. You know, like I said, ESG, green buildings, ESG in terms of modern slavery, labor conditions, and so forth. And so I think for lawyers and law firms, you really need to understand your clients' requirements. And I think of all the foreign clients, you know, Western clients, if you want to call it, but I think the Americans in particular have a whole long list of compliance issues. So I think it's something that as lawyers we need to understand what are their domestic requirements, what are their requirements from their own investors to be able to safely navigate and advise them. Typically in the Malaysian scenario currently, in terms of ESG, there's a lack of green buildings, there's a lack of green power buildings as well, because in a lot of some of these investments, they require a certain portion of the energy to be away from fossil fuels. So those are things that you need to look into. But currently, the topical trending issue, legal issue insofar as ESG is concerned, is really labor, conditions of labor, modern slavery, you know, little things like which you may not think of it as very major, but it is a very major compliance issue for many of these American companies. It's like there was a particular there is a situation whereby a client had a third-party service provider provide laborers, but because of how the third party had engaged these laborers from foreign countries and how they kept the passports and so forth, that became an issue. So I think those are, I think for lawyers and law firms, you really need to familiarize yourself, your clients' domestic requirements. You know, anti-bribery is one of them, Rachel talked about. PDPA is another one. So there's a lot of compliance issues that, you know, not just lawyers, of course, but I think the institutions of governance, stakeholders need to be aware of and be compliant to.
Like what Tai mentioned, right? Like being very clear about what is the key issues, what are the good to have, and not fighting over every point. I think as part of the DD process previously that we ran, the American investors were very shocked that the company was only issuing invoices and didn't have master service agreements. But that's the style for that particular factory in Singapore. But since we have an American in the room, perhaps Jason can share a little bit about how you know, Southeast Asian lawyers can prepare, or Asia Pacific lawyers can prepare themselves for any trends.
Well, I think one thing to keep in mind is that that you know, as Raphael said, there's usually a checklist, which I suppose we could almost call a wish list that a U.S. company is going to come in with in terms of what they're expecting. But it is important to keep in mind that this is not something that can just simply be resolved by a particular form of drafting. Just because you put a clause in there that says we're going to abide by that particular rule. I mean, FCPA is the Foreign Corrupt Practices Act is a perfect example of this. Just because you're saying you're going to abide by that does not mean that you don't actually have to undertake activities that are going to show that you're abiding by that, because there is the potential for an investigation by the U.S. agencies that are enforcing those particular rules. The labor issues that Raphael is mentioning has mentioned are actually quite important in the U.S. right now, and quite closely watched. And a lot of major U.S. companies have gotten into a lot of trouble. I mean, we all hear the stories about Nike and child labor making shoes, or Foxconn in China making iPhones. These are matters that are going to be observed and watched and have the potential to be investigated. And it really only takes one complaint, even if it's not proactively being done by the government entity branch in the US. One complaint goes in. Maybe you've offended one of your partners. Maybe you've managed to make somebody upset, and their means of revenge is effectively whistleblowing or anonymously putting in a complaint about your company and your particular labor practices, or some instance of violation of the FCPA or some antitrust issue. It could be anything. So I think in terms of prepping Southeast Asian lawyers, just Asian lawyers in general, non-US lawyers in general, and in them prepping their clients, they need to, I think it's very important to say to your client, you have a great opportunity here. We don't want to, we don't want to diminish that opportunity, but you do need to be aware that if you take on this opportunity and this partnership or this money or whatever it happens to be, you are probably going to end up being a bit more scrutinized, and you need to be aware of what that scrutiny might entail. And you don't want to end up in a situation where something is done that is considered just standard operating procedure in Southeast Asia, but is not okay for the US partner, and it gets the US partner in trouble. Companies that are entering into these relationships are doing so because they really want to work together, but you don't want to cause a problem with that relationship because you haven't followed up on that issue. But
as a US law firm, I would like to share what we do when issues like this come up all the time. In addition to addressing the US government, we have to deal with the Hong Kong or Chinese government on the same issue. Most of the time, it involves companies they acquired and the act transpired before they were involved. So it is important for us to find out what happened, and also to be perceived as a victim rather than obstructing the investigation. So we reported it directly. We helped them. And in China, I'm sure you know, when they started an investigation, they make an arrest first. And then after that, maybe a year, 2 years later, after the sentence is served, they'll tell you what was wrong. So it is important that we go and have US lawyers, Hong Kong lawyers, Chinese lawyers, and now Malaysian lawyers all deal with the same issue, because it could have problems in all these jurisdictions. And definitely we have to be on the government side, because we are not approving all these acts. One other comment, because I answered it on the question about the operation of a SPAC. Yes, a SPAC has a period, a time period to exist, mostly 18 to 24 months. You can extend it by paying an extension fee, but most of the time, if you cannot find a target, the money will be refunded. It would be the same if it cannot meet the listing requirement, then it loses its appeal as a listed vehicle, and there is no chance for you to find a target. So all of this means the investors will get the money back, no problem, because all the money sits in a interest-bearing trust account. So the only parties losing the money will be the sponsor. They will lose their investment, which will be the cost of forming the SPAC. So I answered those two questions while you were busy doing other things.
Thank you, Simon. On this bombshell note, we have completed 1 hour of this LexisNexis webinar session. Thank you, Simon, Rafael, Jason, Sai for your time. Thank you, LexisNexis, for hosting, and for the participants out there. We hope that we have given you tips on how to navigate uncertain times. And uncertainty means opportunity. So remember to buy property in Malaysia. I'm just kidding. All right, on to you.
Thank you so much. On behalf of LexisNexis, I would like to thank our panelists, Jia, Jason, Raphael, and Simon, and of course, our lovely moderator, Rachel, for participating in today's panel discussion. I hope you all enjoyed it as much as I did, and thank you to all of you for spending your lunch break with us. A recording of this panel will be made available on our corporate websites soon, and if you would like to learn more about AI-powered contract drafting with Lexis Clause Intelligence, please feel free to get in touch using the QR code on your screen, and we would be happy to arrange a session with you. Until next time, thank you and take care.
Thank you. Bye-bye.
Bye.
Bye.